Welcome to the Hindu editorial discussion. My name is Ryan Pinto. Today we are going to discuss the editorials of November 7th, 2020 from the Hindu. So what are the topics that is there we are going to discuss on in the editorial? The two main topics that we are going to discuss is GST on mobility aid and the second one is divorce and alimony. Both of these topics form part of the social issues. GST on mobility aid is going to be focused on equality as well as we are going to see it on the persons with disabilities, how it is going to affect them. The second one is divorce and alimony, more of a question on you can say women issues and how marriages and and divorce and all are affecting the women in our country. So these 2 points are the topic of discussion today on November 7th. When we talk about the mobility aids for the person with disabilities, you must understand there are various machines or you can say vehicles which is used by the person with disabilities to help them move around. In the current scenario, we are seeing there has been GST put on this person, on this mobility aids. Will it help? Will it affect the person with disabilities? We are going to discuss that in the editorial. So the context is the GST levy on mobility aids places a prohibitive burden on the ability of disabled citizens to lead a dignified life. So why are we discussing today? Because the Supreme Court of India, the person with disabilities, one of the person has gone, the petitioner has gone to the Supreme Court of India to remove this additional GST, or you can say the GST which has been put on the mobility aid. And one of the factor we are also going to see it affects it is a question of equality also. How is it a question of equality? We are going to see ahead. But you must remember the context. So on October 27, the Supreme Court of India, the petitioner in Nipun Malhotra versus Union of India argued that tax imposed on these products, which include, so you must remember, tax imposed on the products which include tricycles for the disabled, braille paper, braille watches, was patently discriminatory. Okay, so in on the wheelchairs, tricycles, braille paper, braille watches, on all these there are tax imposed which is discriminatory. A decision to impose tax, it said, was a matter of policy over which the judiciary ought not to ordinarily interfere. So what did the Supreme Court reply? What did the Supreme Court say? The Supreme Court said that it's a matter of policy and we don't have jurisprudence or we don't have the power to interfere. It suggested that the petitioner exhaust his options by submitting his grievance to the GST Council, and Supreme Court instead said, go to the GST Council and submit your grievance there. So just remember the context and what did the Supreme Court say. Now tax and fundamental right. So we are going to look at the whole context in the matter of tax, fundamental right and equality. So let's see. Should the GST Council reject the petitioner's plea, it would be imprudent of the court not to test the legitimacy of the levy. So there is another debate, the power of Supreme Court versus the power of the executive. And we know there should be separation of powers. So can the judiciary come into place? Can the judiciary come into the powers which is taken by the executive? Taxes have a direct bearing on how society is arranged. So just remember this very important statement. Taxes have an important bearing on how society is arranged. Because if taxes are put more on these products, it will only help those who are rich and they will be able to take the advantage. So you must remember taxes have that power where how the society is arranged can be decided by the taxes. The nature and the one second, the nature and rate of the tax imposed on a product can just just a second. Yes. So the nature and the rate of tax imposed on a product can impinge both on person's freedom and on a person's right to be treated with equal care and concern. Therefore, it ought to be well within independent judiciary's province. So why should the judiciary, as I've told you, there's a debate on is it going to be affecting the executive's power? But the answer or the reason you can give is the nature and rate of taxes imposed on a product impinges both on a person's freedom and on a person's right to equality. Therefore, it can come into the uh, you can say powers and the area of the executive. Market forces are at play. Currently, market forces are at play. The executive is saying that let the market forces be at play. The GST regime was launched amid much fanfare in July 2017 with the idea of not only simplifying India's complex and multi layered tax structure but also with a view to fashioning the country into a unified common market. The whole point of GST was to make it a common market in which the levy of GST will subsume all other existent indirect taxes. So the motive of GST was to make it one market, one tax. At the time of its inception, central government claimed that causes of liberty and equality would benefit from the states pooling their sovereignty together with that of the union. So when GST was brought in, it was one market, one tax, or one India, one tax. And the second point was liberty and equality will be able to be upheld because everywhere the taxes are going to be equal and market forces are going to take a role. It means it will be focusing on liberty, freedom. But is it the thing which happened? But what we have seen is that the withering of states fiscal or financial autonomy. So it has given the focus on liberty and equality, but it has hurt the federalism. It is the dictates of the market alone that appear to determine how and what goods are taxed. The levy on commodities used by the disabled is a prime example of this. How GST will make the vehicles cheap? Government is also saying it focuses on liberty, it focuses on equality, it will make the vehicles cheap. How will the GST make the vehicles cheap? That is what the government is saying. I have explained in this slide. Until the advent of GST, mobility aids were immune from indirect taxes. Till the GST came, it was free from taxes. Originally proposed 18% on these devices now reduced to 5%. When GST was brought in, originally it became 18, now it has become 5%. And the context is people are gone to the court saying that this 5% should also not be there. Government is saying it will reduce the prices. How? Let's see. Despite this affront to dignity, the government claims that it cannot relieve mobility aids from taxation because to do so it will incentivize domestic manufacturers. This argument is influenced by GST structure. In particular, the manner in which firms are allowed to claim credit on taxes paid by them in making of the product. Now, what is the meaning? How it will make the products cheap? You must understand in GST how it works is when you are paying taxes as a seller, you can also claim taxes when you purchase the product as a buyer. So means if you are paying 100 rupees and in that 50 rupees you had is the tax that you have to pay. When you had bought these products, say for example you paid 30 rupees as tax, you can claim it back. It means when you are paying 150 at the end, you can claim back 30. It means you've just paid 120. So your cost reduces. So you can reduce the price from 150, you can bring it to 140, 130, anywhere you, anyhow, or any amount which you would like to. So it helps reduce the prices. So very nicely explained. So just remember, in GST, everybody needs to remember, when you are paying the taxes, what happens in GST is, when you pay the taxes or sell the products, you can also claim the taxes you have already paid when you are buying the products. Okay, so you have to just remember that. This argument is influenced by the GST's structure. Let's see how the GST structure is. Under the existing regime, if the maker, say, of a wheelchair, so a wheelchair maker example is given, has paid taxes on commodities that serve as raw material in the process of manufacturing, it will be entitled to claim credit for the tax paid when it remits the levy collected from the eventual purchaser of the product. So, for example, there is a company A, and when it purchased, it paid some taxes. Okay, and then when it sold, it paid some taxes. What you can do in GST is, this tax can be waived off, you can get it back. So your prices reduces. Okay, example is, so if the manufacturer spends a sum of 100 rupees as tax towards the purchase of aluminium that goes into making of wheelchair, and then collects 120 as GST when it sells the wheelchair, it would be entitled to claim the sum of 100 rupees. So when you're paying 120 as GST, when when you paid 100 rupees when you bought the raw materials, that can be minused as input tax credit, and would consequently have to just deposit 20 rupees. The state's argument is that in the absence of putting GST on the final product, the manufacturer will be burdened with the input taxes. Since it cannot claim any credit for those taxes paid, the prices of the final product would be higher, and as a result, the manufacturer will be placed in a relative position of disadvantage. So, what is the government saying? That if we don't put GST, this this input tax claim can't be made. That is what the government is saying. But there are two problems. First, a reading of the various notification issued by the GST Council shows that many other products that are essential to human needs are exempt from tax. So the same thing should have been gone to the other products also. Examples are given like the tampons and the sanitary pads. Why was there no tax levied on those products? So that's the first point. Secondly, the grant of exemption in cases such as these would disentitle manufacturers from claiming input tax credit is a matter of legislative design. So some design or some legislation can be made saying that if you are purchasing aluminium for making wheelchairs, you can exempt them from the taxes and reduce the taxes. Something like this can be made. So it is upon the government to make such designs. So the two problems I hope you have remembered or understood. First of all, other products are not taxed, which is equally important, and secondly, we can make some designs, so it affects equality also. The tax places the tax places a prohibitive burden on the ability of disabled citizens to access the most basic goods, to lead lives with dignity. So, what is the tax doing? The tax currently is prohibiting the uh, disabled to live a life with a dignity. Given that the classification rests on state of disability, it must be seen on any sensible consideration of our equality jurisprudence. Now, this affects equality. So, if we wanted to give dignity to the person with disability, we have to give some concession in taxes because it affects the concept of equality. Okay, so just you must remember Article 14 says equality. It talks about equality. So it focuses on that. The onus must therefore rest on the government to show the court that it had cogent reasons for treating these goods as distinct from other commodities that are exempt from tax. A failure to discharge this onus ought to render the levy illegitimate. They were not able to show the courts why there are no taxes on sanitary pads, but they have put taxes on these mobility aids. So, in Article 14, we talk about equality before law and equal protection of law. In equal protection of law, it is said equals who are similarly placed should be treated equally. So, that is the problem. Taxation, after all, is a tool that is intended to augment general welfare. It is time we recognize that unreasonable levy can deeply compromise fundamental human needs. To free taxing statutes from ramparts of constitution is to risk the entrenching of inequality. So taxation is to actually give general welfare, is to make people equal. Article 39b and c should be considered, but by putting taxes here we are actually creating inequality. We are prohibiting people with disabilities to take things which will help them in leading their life better. So this was the first article on disability, GST and the taxes. We saw the various angles on it. Second article is on divorce and alimony. So currently we are seeing in our society a lot of our society has become more free. It has allowed people to take decisions of their own. The institution of marriage, which is one of the most important institution in our society, is now seen more of a contract, and with more and more independence coming, and people uh, getting connected with the concept of freedom, divorces are on the rise. So that is why we need to have proper rules and regulations for divorce, so that there is no injustice when this happens. So when we talk about divorce, the next factor or the next thing that you should remember is alimony. So alimony is when you get money, when the woman gets money from the divorce, when she leaves the house of her husband. Divorce in the Hindu Marriage Act. So first of all, let's see some basic concepts. Divorce in the Hindu Marriage Act. The Hindu Marriage Act 1955 lays down the law for divorce. Okay, so just remember this. It applies to Hindus, Buddhists, Jain and Sikh. So we have personal laws for the Hindus, Buddhists, Jain and Sikh. It is the Hindu Marriage Act 1955. Under section 13 of the act, grounds for divorce include voluntary sexual intercourse with any person other than his or her spouse, cruelty, desertion for a continuous period for not less than 2 years immediately preceding the presentation of petition, ceasing to be a Hindu by conversion to another religion, being incurably of unsound mind. These are the various reasons where you can seek divorce in Hindu Marriage Act 1955. In addition to this, Section 13b provides for divorce by mutual consent. Section 27 of the Special Marriage Act 1954 provides ground for grant of divorce in cases marriages solemnized under that act. So we are seeing Hindu Marriage Act. We are also going to see the Special Marriage Act. What is the meaning of Special Marriage Act? However, neither of the two acts provide for irretrievable breakdown of marriage as a ground for divorce. So if uh, there is a bitterness in the marriage, there is the relation is not happening properly, that can't be a factor for divorce, which is because it is not mentioned in the acts, that is in the Special Marriage Act also, in Hindu Marriage Act also. Let's see Special Marriage Act. What is Special Marriage Act? It is an act of 1954. It is a law which allows solemnization of marriages without going through the religious customs or rituals. Mostly special marriage acts are used by the interfaith couples. People from different caste or religion or states get married under the Special Marriage Act because they need not go through the religious customs or rituals. It is by way of registration. The prime purpose of the act was to address interreligious marriages and to establish marriage as a secular institution bereft of religious formalities which required registration alone. So the purpose was interreligious marriages. So you have understood what are the things or reasons for the divorce which is given in the Hindu Marriage Act, and we have seen what is Special Marriage Act. The context we are studying this today is the alimony guidelines, what the courts have said. Early enforcement of maintenance law is a must to protect dependent women. We are seeing in the marriage when divorce happens, the most affected party is the women, because in India we have a patriarchal family, and the women have to leave their jobs and their education and very various things, and they are in complete dependence of the husband. But when divorce happens, it it makes the women vulnerable. The inevitable reality seems marriage before completion of higher education. Girls are married off early and bear children long before they should. The triggers of a state of poor maternal health and is one root cause of the high levels of child stunting and wasting in India. Another factor why this law alimony guidelines is needed, because girls are marrying at a very early age. They get children, they bear children before the age which they should, and which leads to child stunting, wasting in India, leaving the girl or young woman in extreme distress because often she is not financially independent. And as I have told you, there is dependence on the husband. So, constitutional safeguard. Article 15.3, which states nothing in this article shall prevent the state from making any special provision for women and children. So, Article 15 talks about prohibition of discrimination in matter of race, caste, religion, sex, place of birth. That's Article 15. But it also states you can make special provisions for women. And second, that is how women are protected. Second article is Article 39. So whenever question comes, in which article there is protection of women, first Article 15 clause 3, and then Article 39, which states state policy towards equal pay and opportunities for both men and women, and protecting the health of women and children are two key constitutional safeguards. So Article 15.3 and Article 39, which talks about equal pay and opportunities, are for women. So just remember and use it in your answers. Now about alimony. Guidelines have been given by the court for the alimony. The court ruled that abandoned wife and children will be entitled to maintenance from the date she applies for it in a court of law. So, some points now we have to remember how the courts have seen to it that the women are secured. First of all, when they apply, at that time the maintenance starts. They did not wait for the case to get over. Secondly, it was by Justice Indu Malhotra and R. Subhash Reddy of the Supreme Court. So, what were their guidelines? Number one, reasonable needs of a wife and dependent children. So, that needs to be taken care of. The reasonable needs of a wife, her educational qualification, whether she has an independent source of income, and if she does, if it is sufficient to follow, if it is sufficient family to follow for family courts, that is for cases, magistrates and lower courts on alimony cases. So all these things are taken into consideration. Cases are known to drag on and to acquire cobwebs, worsening the misery of vulnerable women. Laws including the Protection of Women for Domestic Violence Act 2005, Section 125 of the CRPC, or under Hindu Marriage Act 1955, they all cover the divorce. So just remember which are the laws. So first we saw in Constitution where the protection is Article 15.3 and Article 39. Second we saw the Acts, Domestic Violence Act 2005, Section 125 of CRPC, and the Hindu Marriage Act. Hindu Marriage Act I have told you. We also saw the Special Marriage Act. So, in conclusion, an order or decree of maintenance may be enforced under the various laws and Section 128 of the CRPC. So, for maintenance, it is Section 128 of the CRPC. For women in India, especially the poor who are often overlooked in discourses, the top quotes words that maintenance laws will mean little if they do not prevent dependent wives and children from falling into destitution and vagrancy offers a glimmer of hope. So these guidelines to help the poor woman during the time of distress and when the husband leaves is actually going to help a woman a lot. So that's all for today. We have two articles. So first, as we discussed on the role of or you can say GST in mobility aids. Secondly, we saw on the alimony and divorce issues. So just remember uh, before I leave, just want you all to remember the art and science of asking questions is the source of all knowledge. Thank you.